All right, good afternoon, everyone. Thank you so much for joining us today for today's activities. My name is Christopher Douglas. I'm Assistant Professor of Government here at the Northeast Campus. Welcome to the 2021 annual celebration of Constitution Day. There's a speaker here to provide you information and enlighten you with some details about this important document that guides the governance of the United States. But before I introduce him, a couple things. I wanted to hold on. Feedback. So if you're joining virtually, please keep your microphone muted. Additionally, please make sure you sign in to make sure your attendance is recorded. Student development team will work for you to sign in for those on campus if you haven't done so already. And at the end of this event, the virtual attendees can sign in as well. There'll be time at the end for questions, but there'll also be an email link that'll show up one of the first slides for you to forward any questions to. So without further ado, it's my pleasure to introduce the Constitution Day speaker for today. Cesar Diaz is an attorney and first-year professor of paralegal studies and political science at Texas Wesleyan University in Fort Worth. He's been a government adjunct instructor at TCC for approximately 7 years. In that position, he facilitated both Texas government and federal government courses at the Northeast Campus and with TCC Connect. Mr. Diaz has also practiced law in a solo capacity as a staff attorney with Legal Aid of Northwest Texas. And he's going to bring all of that experience and legal expertise with his discussion today. Hey, Federalism, where are you from and where are you now? So without further ado, I'll turn it over to Professor Diaz. Please, Cesar, take it away.
All right, can you hear me?
Yes, sir.
All right, and can you see the screen? Yes?
Yes, okay. We can see it.
Okay, so before we begin, I do want to let you know that the chat is not working. So please, if you have questions or any kind of comments, you can email Christopher Douglas at the email that's on this slide here. So it's christopher.douglas@tccd.edu. And he'll facilitate asking those or bringing forward any of those comments as we go forward. So as Christopher said, the topic today we chose for Constitution Day was to discuss federalism and its impact on our government. And so to begin with, I do want to give a little bit of background of where federalism initiated. Where does it, because it's, as you'll see, it's not really explicitly mentioned anywhere, but it is found just about everywhere in the Constitution. So as we go through that and then move towards just a highlight of some periods in history where federalism has been distributed, I guess, in different ways between the national government and the state governments. So, and then from there, move into where are we now and try to pose some questions about some pressing topics that will have impacts nationally and in the state of Texas. Okay. So as we begin, I call it the fertilization stage. So where did this idea of federalism come from and grow, have that seed to actually germinate into what we have now? And I go back to Alexis de Tocqueville, who admired greatly this concept of federalism and dual government that we had. And I think this quote captures his admiration well and the plight that the founding fathers had in bringing forth this idea of dual government and increased national power, centralized power, because we did begin at the colony stage, and of course, fought a revolution to get rid of or get away from under the thumb of what we felt was an oppressive dictator or tyrannical government. So it wasn't going to be easy to change that form. And a lot of those things originated from, of course, the weakness of the Articles of Confederation. That was, a discussion that came about as soon as we ended the Revolutionary War. Right, there were lots of debts owed, and there was no power to force states to pay anything. So, the states voluntarily gave their power and could, move forward with complying with any of those things or not. And of course, we depended on state revenue because there was no centralized government. We had no military. There was a fear that the British were going to reorganize and come back at us. And also just the idea that if we were going to survive as one entity, we knew that things would more likely need to change. And then there was, I call it like the impetus or the seminal event that really pushed forward this discussion. And some people argue that led to the actual convention, and that was Shays' Rebellion. So to give a little bit of background on Shay, a farmer, but also a veteran of the war. And they faced heavy taxation when they came back from the war. So all these things were going on. You had veterans that were promised in a time of war that when they came back, they would at least have some time to pay back debts, and also, have limited taxation. And those things didn't happen. So they weren't happy, were under the threat of being foreclosed on, and organized to rally about 1,500 men eventually to go fight in Massachusetts. And there was no centralized army to defend against this. So it wasn't for a private group of citizens that got together and quelled off this, militia. It would have been very difficult to forge ahead, I think, as one government. And it shocked the founding fathers, right? To even those that were against a strong centralized government came together, right? So you had those two groups of Federalists that wanted that strong central government, and the group of the anti-Federalists that wanted to remain the way it was, where the states controlled the power. And that led to what I call the conception, right? So after you had this impetus, of course, we had the idea of moving towards a more perfect union. And as I mentioned previously, the idea or the word federalism doesn't even show up in the Constitution. Right? So that's one of those things that I thought was great to discuss now, because the concept is heavy, but it's absent in wording. But the structure is replete, right, with the idea of a shared government. And you see it beginning where the framers said, hey, we're going to split this atom of sovereignty, and we will have this idea of a federal government, and then move forward to also keep the states sovereign in areas where the federal government is not clearly defined to act. So one state and one federal government, and this is clearly apparent in Article 1, which created our legislature and gave them a series of powers. Some I list here, right? Of course, like common defense, a great fear that we had that we would be attacked again by the British. The power to tax, right? To collect, to pay some of those debts that we owed. Currency, because every state had their own currency. So the power to create currency and exclusive right to do that. The power to declare war, and then commerce, among other things. In addition, there were a couple of other articles, sections under Article 1 that prohibited the states from doing certain things like, having diplomatic relations, right, with other foreign governments, and also created the concept under Article 6 of the supremacy clause, right? That the federal law or the national law, anything that was at the constitutional level, was supreme to any state law. So if there were ever a time when those two conflicted, then the federal law would prevail. And then as far as for the states, there was, language that said where the Constitution was silent on powers given to the legislature or the executive branch or the judiciary, then those powers were retained by the states. And later on, those were formalized a little bit more. One in the form of the Ninth Amendment, which is a sort of odd amendment, not really used, has never been used on its own, been used in conjunction with other things by the court when they've interpreted the constitutionality of a law. But it gives the rights to citizens, right? So where the Constitution has failed to reserve powers to the federal government, then those are retained by the citizens themselves. But more so for the states and federalism, the 10th Amendment, that reserves any power not explicitly or implicitly given to the federal government by the Constitution to the states. And then, of course, in the other two articles as well that we'll find, right? And those most often show up in executive orders, where the president has been given broad power to issue executive directives just by the power given to him by that Article 2. Even though there's no direct mention of that ability, it's been interpreted to be the executive's right as he carries out forward, executing any power given to him as commander-in-chief and the overseer of the government. Right? So, and then Article 3, the judiciary, which we find later on in a case that with Barber versus Madison and Marshall determines that the supremacy clause is really given to the judiciary when they do judicial review and determine whether something is constitutional or not constitutional. So evolution itself of federalism might look like this depending on what side you're on, right? So for the federal government, those that really want a stronger federal government and want the protections of what may come, they may see the states doing, serving that role of the zombie here, coming back on us. And for the states, they may be that want, the sovereignty of the states to determine those issues and don't want the federal government to be involved. They may see that zombie as the federal government. So I guess it depends on which side of the coin you're on. So as I mentioned, I'm just going to briefly highlight some of the periods and I guess philosophical and practical approaches that we have had in the past with federalism. And not really going to look at the timelines, but at the overarching themes. So we had this idea of dual federalism in the very early stages of our country, moving into the early part of the 1900s. So this idea is analogous with the layer cake federalism, what they call. And the themes are that the state and national government each are sovereign, and therefore they're equal. And they have particular powers where they're allowed to rule on. The relations between them are more contentious, right? There seems to be more tension because it's one of those ideas of where does one government's power end and where does the other one begin? And in this time, the national government gained a lot of strength. And a lot of it was for economic reasons because we look at, for example, the Depression period where the states relied heavily on the national government to support them economically. And in overall, really just as we built an economic juggernaut in the country, that a lot of it was the government playing a role in controlling this and really commerce, right? That idea of the Commerce Clause, which was mentioned in Article 1, Section 8, at this time flourished to mean that there were a lot of things the federal government could control just by the Commerce Clause and commerce between the states. And then we moved into later on to what is considered cooperative federalism. And that's the philosophy and practical approach that is more like a marble cake federalism. And the concepts being that federal, state, and local governments share responsibility for almost every function. And so they're very intertwined. And as time went on, right, the national government's power grew here, but in a regulatory fashion, away from economics. Okay. And then as we moved into the era that we're really in now, that started, say, in the 80s, this idea of newer federalism, we saw like this concept of devolution, where the power shifted from the federal government back to the states, and moving that a little away from the federal government, weakened it a little bit. So where are we now? And here in this point, I wanted to bring up some three concepts that are, or issues that we're presenting. One is immigration, right, which seems to be clearly defined as a federal role, but we'll see where states seem to say that they have a bigger interest and are trying to make some gains in those immigration policies, right? The second is health. Not so much the health care, because that was a big debate and continues to be so in the last 10 to 15 years with the Health Care Act, but more in the sense of the pandemic and what's the role of the federal government to ensure that we can stop something like that idea of health. And then thirdly, privacy rights, and looking at that in the context of Roe v. Wade and what's happened recently to try to chip away at those rights to privacy, and also look at where do each one of these issues get their power or in the Constitution, right? So here we are, this current conjuring, kind of like this sheet back and forth, deciding who's going to play a major role in each one of these issues. To set the stage for immigration, I'd like to say that, many state laws are preempted by federal law. So this one is clearly outlined in Section 1, Article 8, Clause 4, where the Congress is given the right to, determine naturalization, and that from there come all the immigration laws. But it's not that simple, right? So the states have been, even though the federal government's been given broad power when it comes to regulating immigration, there are times when states are permitted to act. For example, employment, right? So states are largely responsible for employability issues. And so when it comes to being employed, you have to be a citizen, you have to have a social security card. So those are where the state can chip away at some of that. Also enforcing federal immigration laws, right? The court has determined that there are instances when a person, for example, has been detained for another reason, and a felony is involved in particular, and their status is, immigration status is not clear or questionable, then states have been able to act in those instances. Denying federal benefits is another big area, right? So there's this perception that people come to this country and they get all kinds of federal and state benefits, and that's just not the case, right? You have to qualify for those things, and those are areas where state governments are heavily involved in determining eligibility in both state and federal benefits. So in those areas, courts have seen it okay whenever states have passed laws to try to limit immigration or benefits immigrants can get coming here if they've done it in a way that's not documented. Okay, so we've had recent areas where states have, pushed to the limit and actually crossed the line. Arizona is a state that did this back several years ago in 2007. They passed a bill that was SB 1070, 2008, somewhere in that area. So they wanted to do 4 things, and 3 of those the Supreme Court struck down. One of them was their Section 3 SB 1070, which made it a state crime to, be here in the United States without failing to register. And basically what that would have created is a situation where everyone, even legal immigrants, would have to carry around proof of their U.S. citizenship to some extent, because it could be questioned at will. Second was the Section 6, which said if any warrantless arrest by an alien would be okay, right? It would be permitted by state police and they'd charge it as a state crime. And then finally, Section 5 would make it a criminal act, a state crime, for someone who was undocumented to search for work or hold a job within the state. And in each one of these cases, the court struck them down. In the first case, of course, saying that even though we're looking at documentation, that's very clearly preempted by the federal government, right? The federal government is the one that determines citizenship status, so the states are not to be involved there at all. As far as the second one on warrantless arrest, the court was very leery of, profiling cases here and just being able to stop anyone, right, without cause even, just based on the fact that they believe they might be undocumented. And finally, here the court said that, the federal government hasn't weighed in on this matter, but if anyone's going to weigh in, it would be them and not the states. The only one that survived was Section 2, and it basically stated that if there was an arrest for someone that was related to something else, and an incident to that arrest, they checked documentation status, that was legal. And I think, scholars on this, do worry about this area of the law still, right? Because it could lead to maybe some overarching or overreach by law enforcement, but that's been held to be constitutional. So if there's an arrest and because of that arrest that was for another reason, officers find out that the person's undocumented, then they can move forward to contact ICE or immigration to come and detain the person after he's been detained for whatever reason he was stopped, right? So they would deal with the matter that he was stopped for first, and then contact ICE to release them to their custody for whatever proceedings they wanted to move with forward. So it brings us to some recent immigration policies by the state. So first, Texas has decided, in this year that even though the federal government, because of the switch in the executive or change in the executive branch, there were decisions made to stop building the border wall, which were begun by the previous executive office holder. And Texas has decided to continue to do that here, right? And with their own funds, to the tune of about $25 million right now for a couple of miles, but they want to expand and actually complete all of what the previous administration at the executive level wanted to do. Some of the hurdles they're facing, of course, are funding, and because, right, I mean, as a state, we rely heavily on limited taxation. So where we get that money is going to probably be an issue. And then second, land disputes, because part of the land that was going to be used was one captured by the federal government under eminent domain, and second was federal land that was going to be voluntarily handed over for this purpose. So those two things are going to be challenged and will come up as we go along. A second thing are arrest of people that are crossing the border, right? So those arrests are being done under state law for criminal trespass. So in Texas, we do have a criminal trespass on private land. And so that's what's being used. And, some of the hurdles are that we did build a detention center in Dilley, Texas, which is south of San Antonio, and have filled it to capacity pretty much now, because there are a large number of undocumented persons that are crossing now. So the detention, again, we find issues in funding, but there's also compliance issues, right? So when the jail was taken over, there had to be a lot of renovations to meet federal guidelines. And then what do you do when you release them? Because here, the state and the courts have been clear, they're preempted from trying to deport them and move them back across the border. So their remedy is to call federal law enforcement agencies, with ICE, and let them know, at the time of release, here's this person, do you want to pick them up? And absent that, then they just have to release them back into the general public. Second, or third, there was a recent initiative this summer where the governor signed an executive order at the state level, basically telling state troopers or allowing them to initiate traffic stops of people he felt were if they felt they were transporting undocumented immigrants or migrants, and they were a risk of spreading COVID-19. So he used the reason used was not a criminal reason, but a health policy reason, and that's listed in the federal code. And they were charged with rerouting them to the original origin where they came from, and if the person refused to turn around, then to seize their vehicle. Right? And at the moment, that's been ordered, halted by a court order. So that's one area that's going to play out, I think, as we go along, because it'll make its way up the courts, eventually to the Supreme Court, and we'll see how they'll rule. Recently, the Supreme Court did side with Texas on a suit, because the previous administration had basically said, if you're coming here for asylum, you're seeking asylum in the United States, then you can't come right into the United States unless you're from the neighboring country. So the way the law sits now, the previous administration basically stated, if you're crossing a country to get to the United States, then you have to stay in the country that you crossed first, right? Now, if you're a border country, you could seek asylum the old way. And basically, asylum seekers, the way to seek it is to come to the border and claim it, right? To say, I am seeking asylum, and then you get processed by INS and you're released with a court date to immigration court. But the previous administration stopped that. Now the Biden administration had wanted to revert to the previous policy that it didn't matter if you came, for example, from Central America and had to cross, a couple of countries and Mexico to get here, right? A couple of Central American countries and Mexico, you could still claim asylum. But the Supreme Court saw it, stated no, that the previous administration's policy needed to be reinstated. and basically saying that if you come from countries like Honduras or Guatemala, where you have to cross Mexico, a neighboring country, then you have to stay in that country while you're seeking asylum. And then the second thing was went against Texas, right? The Biden administration basically won on prioritization of deportations, and they don't have to necessarily follow the request of Texas asking for anybody to be deported based on the health reasons. They can go back to the original prioritization like the executives have in the past, and at this point prioritize felons with that are like high risk or violent felons, and put them at the top of the deportation list and moving those other people to the bottom. So that's that on immigration. And as far as health, I mentioned looking more at pandemic control measures. So many of these, right, don't come from the same area where we saw immigration law comes from, right? Immigration law coming from that Article 1, Section 8, Clause 4 to the legislature, and then, of course, directly to the executive to carry out those laws, correct? But health law, more through executive orders, right? Beginning with the previous administration. And many of the measures were things like travel bans. We didn't see any bans within the United States from state to state, but we did see, not at the federal level, right? We saw measures between states where one state might say, if you came from another state, then we require you to be tested, right, or to be quarantined. And you saw Texas do that with people coming from New York, and New York do that from people coming from Texas at different points in the entire the beginning of COVID. But at the federal level, the travel bans were more exclusively for countries, right? Either us going to countries or people from other countries coming here. So those were done through executive order. Closures. We saw lots of closures both at the federal level. For example, to this day, you won't see Social Security hearings in person. You see them done telephonically. All kinds of federal buildings that were closed, and then closures from the state level. So here you truly did see a sharing of that power, right? Even though we had the federal government requesting states follow a particular advice from the Centers for Disease Control on closures, the states were the ones that acted, and several did follow similar rules. Texas even closed schools, like you saw, nationwide. Pretty much everybody going that route and going to an online status, and we saw that at TCC, right itself, where any state school was closed. And we just got back a few weeks ago. Distancing guidelines, right? Both at the state and federal level, right? So both working in these through executive actions, right? Because neither one of these really waited for any kind of legislative action. Mask mandates. Many states, they're pretty much gone, the mask mandates. But federal mask mandates are still around, right? So if you are going to board a plane, you're going to have to wear a mask because that's interstate commerce, federal transportation, all the flights, right? And even if you are in, say, metro, where you're in a federal, like say the District of Columbia and that entire area, then you're going to have mask mandates. Relief packages were heavy, right, from the federal government to the states. And you saw eviction moratoriums coming down from the federal government and states voluntarily passing laws, state courts. So here in Texas, for example, we had our Supreme Court follow and actually create orders from the court. They would sign several orders that changed following those federal guidelines to prohibit evictions. They started with the previous administration in September of 2020, and they were extended a couple of times by that administration, and then once more, or a couple of times more by the current administration. Now, this is where you saw a definite departure from the state and federal government, because in Texas, starting in March, even though the federal government had extended the CDC moratorium, our Supreme Court did not. And that gave the local courts, judicial, the justices of the peace, a lot of leeway. And you see that most of them decided not to follow the federal rule and went back to evicting people for non-payment of rent. And in foreclosure forbearances, those being mostly funded, or so any mortgage that was federally backed, you automatically got a forbearance just by reaching out to the lender, right? And then requiring negative COVID tests for travel. So that brings me to the big one, right? And this is the one that I think we'll see a lot of battles in both the federal and state government, because for the most part, required vaccinations are not new to us, but they haven't been, for the most part, a federal oversight. They've been state controlled. And we see those most often in the education agency. So in the education code, we see the vaccination requirements for people coming into not only K-12, but people coming into like Tarrant County College, that at a certain age, until you reach a certain age, you have to take meningitis vaccine, for example. It's required. So how has it looked for us? So recently, our executive branch signed an order requiring all active duty troops to be vaccinated by the end of this year, December 15th. All National Guards troops, they have to be vaccinated by 2022, in this midsummer or in the summer. All government employees. And there's no option of regular testing to opt out. So if you're a government employee, and that encompassed the Postal Service, which is kind of a pseudo government entity, because it's not really funded. It has to. The postal office is only financed by its own operations, so it included them. Same standard for employees of the federal government contractors. So if you're a government contractor, must be vaccinated. And then healthcare workers at facilities that receive Medicaid and Medicare. So tying funding to this, right? So you receive this money, you're at risk of losing these funds if you don't make sure that your workers are vaccinated. Recently, the Department of Labor is going to be required to ensure that all businesses with over 100 employees are vaccinated, or here's where it's a different option than those government employees. If they refuse vaccination, then they're required to test weekly. And there are significant fines that are imposed for non-compliance. And where I think we're going to see the first battle is going to be that there is one state where Montana, which has prohibited employers from mandatory vaccination. So they deemed it discrimination, violation of state human rights. So I think that's where we're going to see a clash of the two. Will an executive order from the federal government supersede the state's right to, prohibit vaccinations, and maybe others to see does the executive branch actually have the power to mandate these kind of vaccinations in some of these other areas that we just discussed. And then finally, the right to privacy. And I focus on Roe versus Wade because it's a hot button topic, the latest Supreme Court justice to be confirmed, Kavanaugh, in his hearings, he stated that he felt that Roe versus Wade wasn't settled all, but it looks like that may not be the case. And just to kind of give an idea of what is the current standard, as far as prohibitions on abortions, because it's not so much about life, even though the argument is right on pro-life or pro-choice, but it's on privacy, right? A woman's right to privacy in terminating, determining what will happen with her body. That is the ruling from Roe. And the current standard of viability is still there, even though it's been chipped away a little bit by cases like Casey, where the court stated that there can be restrictions on restrictive laws pre-viability. But up to now, viability is still the standard, right? So a woman in the first 6 months could terminate the pregnancy, even though states can require some other, what should I say, could require people to go jump some hoops. For example, it could require you, if you're a minor, that you have to tell your parents. They found that to be constitutional. They could require you to be subjected to a sonogram. That's been found constitutional. Many of these measures, they don't keep you from terminating prior to prior to viability, but we're about to probably see a real shift in this landscape, because there's a couple of cases that are about to be heard. One of them is a Mississippi abortion law, which prohibits any termination of pregnancy pre-viability, right, after 15 weeks. So the viability standard is 24 weeks under Roe. And then a more aggressive law out of Texas, right, which is the heartbeat bill. And it bans any pregnancy as early as 6 weeks, right? So, and then what Texas has done is used, I guess what would be called a clever judicial maneuver to avoid judicial review. They are not the ones that will be enforcing this law. They passed this right to the private citizen to enforce. So anyone that would like to, they could, if there's an abortion, can sue the provider or anyone that has aided in the abortion, someone that gave the person a ride, for up to $10,000. And it doesn't even have to be a person that's connected to the person that got an abortion. So I think opening up the door to groups on both sides, to in particular the pro-life side, to go after some people that are terminating pregnancies beyond this. And scholars that have weighed in on this law wonder what the Supreme Court will say, because if a law like this is permitted, right, where private citizens can enforce, then we could easily see it be placed, say, in a more liberal-leaning state like California on gun rights, right? So say if someone were to be killed, then would you give the private citizen the right to go and sue the manufacturer plus anybody else that might have been involved in that chain of acquiring a weapon or ammunition or that kind of deal? So, and also the issue of standing, because that second bullet point, right, not needing to be connected to the person that has an abortion. There's a long settled legal doctrine that, for you to be able to bring any kind of suit, you had to have standing, and that means that you had to have an interest in the case, right? So in the past, you might have been able to say, well, to have standing, you could be the person that is the father per se, and they bring the suit. But here, it could be anyone that's not even connected to the person who's terminating the pregnancy. So a lot said there. And I'll say I do want to open it up now for questions, and I want to go back and revisit those issues. I hope as we look at that you think about those issues of immigration, of health, and in particular the vaccination, and the right to privacy that we're looking at, and comment or ask questions around those issues, because they're definitely going to determine, what governmental entity, the federal government or the state government is going to come ahead on some of these and lose ground on some of these. So with that, I'll hand it back to Christopher to see if we have any questions or any comments.
All right, so if the students have any questions, please email them to my email address. And Cesar, if you can hear me, I'll start you off with one.
Sure.
Could you talk a little bit about what you think will happen with vaccine mandates to businesses if states object to object by the states, but the businesses don't object? What's going to be the result, or what potentially, or how federalism going to potentially impact on those decisions when we talk about business mandates?
Yeah, I think looking at the court that we have right now, in some of the recent rulings, I think it's going to be difficult to, if a state challenges this, right, that they'll side on the federal government side. That's just my opinion. I think on the federal employees, I could see the court saying that the federal, like the executive branch has a say in that, right? Because ultimately they're the branch that oversees the entire federal government. But extending that to businesses with over 100 employees, I would really love to see because you had to have met with attorneys when you were drafting this, what the thought process was around that. And I'm assuming it's going to be under the bigger umbrella that, look, the federal government has always had a say on employment, right? But this, I'm sure states are going to make the argument that they also have a lot of say on employment issues, and how that's going to, I guess, damage their them economically or what have you. So. Does that make sense? Does it answer your question?
Yes, it does. It does. I have another one that's related to some of the information that you were talking about. So you brought up immigration and how specific example of Arizona is a state that created the Senate Bill 1070, and you mentioned some of the activities that are happening at the border in Texas. How does the rights of states or the perceived rights of states impact what steps or measures they take to thwart immigration if it's in conflict with the federal government? So maybe talk a little bit about what resulted in Arizona and maybe what potentially might be the case with some of the activities that are happening in Texas as it relates to immigration.
Well, I think coming out of that, the governor of Arizona felt that they had won, right? Because they did survive. One of those survived, and it was the one that basically said, hey, if you stop someone for another valid reason, and then you want to check their immigration status, they're not prohibited from doing that. It's not unconstitutional. But, they were thwarted on some others, right? Because I think the concept of being able to detain someone just to check their immigration status absent another valid reason or probable cause would have opened up the door to, nearly, I'm sure every border state would have passed a law just like that. And I think we would have had a lot of issues of racial profiling. So if it had survived, I think you would have seen it die later, because that was one of the discussions the court had, is should we even stop these laws before they're implemented, right? In particular, that one. And then the others, those are preemptive in nature. So you're not, as far as, are you as a state, do you have the right to confirm that someone is a citizen and ensure that they're registered. I think that one's settled. There's no way we would ever see a state get that power. But in Texas, I'm seeing. If you just saw yesterday, I saw a lot of news media, media and social pages, social networking pages that have what's going on in Del Rio, Texas, right? That crossing, and you have several thousand people that are wanting to come across, and the states, of course, their argument is like, if the federal government is not protecting us from these crossings of undocumented, then how far can we go? And I believe we're going to see, some of this, because like I mentioned, we've incarcerated a lot of people, thousands. I think it's up to over 6,000 people based on trespass. But our kind of hands are tied after that. And then as citizens, what will, even though the state has the right to also, or the governor to hand out executive orders, what financial burden are we willing to accept as a state? So I hope that answered that.
Yes, it did. We are going to put a link into the chat to have a Google Doc for folks to log in and, again, make sure that they get credit to sign the attendance sheet. And please look for that. It should appear hopefully in a second. And I don't have any more questions that have appeared via email, Cesar. So if you don't have any concluding remarks, I guess we'll wrap it up there.
Yeah. I guess the only thing I would say is that, this concept of federalism is probably alive more now than we've ever seen it, right? Because with the pandemic and, the concept, like, the whole idea of a more perfect union that the founding fathers had, that the best government would probably be a division of government. But when you have cases like a pandemic, should the federal government's power be expanded and to, almost authoritative level to try to quell something like this, I think is where people will go. Like, what's the best answer to that? So I'll leave it at that, I guess.
I have a couple of questions that have come in. There might have been a delay, so I have a couple more for you. So not quite finished yet.
Sure.
Somebody's posing the question: does the heartbeat law in Texas portend a future trend of similar design laws on other constitutional issues in many states? Kind of a sort of backdoor to federalism. So this student is questioning how might this be expanded beyond those issues that you were talking about as it relates to reproductive rights and abortions in Texas and other states. Is there an opportunity, or might there be an option that this might expand beyond what it has already?
Yes, and I think that, from what I read from scholars that have weighed in on this topic, I think that's the biggest thing that they think that the Supreme Court may really struggle with, because if they allow this to become law and actually rule broadly on it, right? Because this in a sense could try to rule narrowly, but if it's a broad ruling, then think about it, like gun rights, because for 200 years, the courts were pretty much silent on guns, and it was more like the states had the right to limit I guess gun acquisition. They could whatever laws they want. It wasn't until recently where DC and later on Chicago had gun laws that the Supreme Court weighed in and said, no, that's an individual right and that's not a state's right. So could you see a thing to say, okay, fine, if we're not going to be able to have limitations from the state or federal government on this, then let's pass a similar law where anybody that's killed with a particular weapon, we can sue the gun manufacturer and anybody that was involved in that transaction. So, and you pick a law that you don't like, the balance of federalism, and once, what's good for the goose is good for the gander, right? Kind of thing.
All right. I got one more for you. And for the students, hopefully you can see the screen. There is a link that you can copy into a web browser to sign in for attendance. So we're trying to manage through that. So you can copy that, or paste that rather, type that into the web browser. Another question that I have for you, Cesar, comes from another student asking about legal. So this is right up your alley. So Dominique Jackson wants to know, how do the courts balance what citizens believe is morally right, or is that a concern for them as they make decisions on the various cases that they might hear in relation to disputes between the states and the federal government? How does morality play, or how do the judges or justices that might be listening to a case take into consideration the morality of the public, or what citizens believe?
Great question. I think, morality, there's, I look at it from the lens of the individual, right? Because here's one of the concepts of federalism that is sometimes lost, that it's only division between the state and federal government. So it's when the state acts in a particular way that offends the Constitution that we see a possible, overstepping of the state. But that same protection isn't held out to the individual, right? So the individual's protected from any encroachment of their rights that are specifically listed in the Bill of Rights, right? So we see that in the form, and that didn't come, right away. It took, over 100 years for those things, for us to see the extension of the Bill of Rights to the states. But I think, that if an individual were to bring up these same topics, whether it's for moral or other rights grounds, the court wouldn't necessarily listen. So I think, the states have, the local government's power resides only because the state gives it to you. So they're unitary in nature, as opposed to federal, that division of federalism, right? That's one, I think, point that Dominique, try to address that question from Dominique. And second, the court, even though they say morality is not, I think we have instances where justices will look at those issues, right? And you don't have to go much further than Texas again. We have a famous case called Plyler v. Doe, where an East Texas school district had decided to require social security numbers for every student that was registered. It was challenged, and it made its way to the Supreme Court. And the court, on a 5-4 decision, found that was unconstitutional. The 4 judges that dissented said, look, education has never been determined to be a fundamental right. So we agree with what the majority is saying. The majority here said, look, if we allow this to happen, there is going to be a second-class citizenry in Texas that is not going to be educated. Their pipeline is going to be straight to possibly like the prison system, right? Because they're not going to have the same opportunity. So I think the court made a moral call there. They, even without saying it, and even the dissent said they agreed with that. Yes, Texas will have prisons filled. They're going to have an uneducated population, a large group of people, but let Texas learn. Let them learn by experience. It's not our right to come in and make that decision. So I think you can see clear examples where morality has played a role in decisions. But even though the courts will say that it's not, it's the Constitution that they're supposed to be looking at. So. Does that answer the question, Dominique? I hope so. Yeah.
I think it does. I think it does well. So I have another question. Again, I want to remind students to go ahead and complete or type in the information they see on the screen now for the attendance. And for those students who've sent emails, I've sent that link to you so you have access to that to provide feedback and make sure that you put your name in. Evan asked another question that's kind of timely and related to some of the political climate that's happening right now. They asked, do you think the extreme political polarization we are currently experiencing is a threat or concern to federalism at all? And you can even make it broader than federalism. How is the polarization impacting just the general governance of the United States in terms of how the Constitution is operating? But specifically, Evan wants to know about federalism. How is this polarization or hyperpolarization, some might call it, impacting or experiencing federalism or concern to federalism?
Yeah, I think it's a great point, and I think it is impacting it greatly because, you know, as I mentioned in the piece, you know, when we talk about the federalism and its creation, we look largely at Article 1 and the powers given to Congress, and we look at some of the other powers given to the other two branches, but ultimately, in the Bill of Rights, right? But ultimately, outside of the Constitution, those powers, you know, matter. And so, for example, does it impact Congress's ability to weigh in on federalism? I think it does when we have a Congress that's often stalemated, right, and can't make a decision. So some things that Congress might well have the power to make a law concerning federal, the federal government's ability to do something. We can't even pass a law and I think immigration is one of those things you can look at in that, you know, if you look at the representatives as a whole and the country as a whole, think the belief is that we need some kind of reform, but there's so much polarization that no one wants to make that decision, and you could have an impact on federalism right there on that issue, and you see it in the executive branch because once that switches and we have a much more powerful executive branch than when the founding fathers wrote this Constitution. Because we have more and more presidents that use the power of the executive order. So yes, I think that as well. And you don't have to look further than the decisions the court's about to make to see their impact on federalism. And it's largely drawn on that polarization. I do think so.
Excellent response. Thank you so much. I mean, the idea of polarization and several of the ideas that you brought up with federalism today really resonate with decisions that the court are in the process of making now and next week. So all of the information that you're providing is very timely and very effective for those in attendance and those watching to kind of have a better understanding of the system. So with that, I want to thank you, Professor Diaz, for all the information that you've shared, for the examples, the great responses to the questions. We appreciate the engagement of the students, all of those who attended live event, and for those of you that will view it later. Thank you so much. Happy Constitution Day to everybody. Again, thank you very much, Professor Diaz. Everybody else enjoy the rest of their day.
Thank you, Christopher. Appreciate everybody watching. Thank you.
Take care.
Bye.